Welcome to the section of credit instruments and legal documentation. We've already covered some of the items that are in this presentation, but I feel like it's important that we go through and tie together some things with regard to how we uh, use legal documents in terms of credit. One of the things that we often run into is the contracts. There's many different places that we see contracts. Whether it's a rental agreement, for instance, for your apartment, that would be a contract. Sales contracts, different types of contracts, and some of the essential elements that are in a contract pertain to the parties that are in that contract. They must be legally competent. In other words, someone who is a minor cannot go into a contract and expect that that contract would have any remedy. Additionally, the subject matter of that contract must be legal and proper. There must be an offer, an acceptance within the contract, and some consideration. The promissory note is a form of a contract. It's a legal document that says that the borrower promises to repay the loan based on the conditions of that loan document. So the promissory note has to meet all of the factors that are related to a contract. Now, notes can be secured and unsecured. The purpose of security or collateral, as we refer to it, is to reduce the default risk of the note. Some of the forms of unsecured loans that you have would be your credit card. In other words, there is nothing of security there with the credit card other than your promise to pay the credit card on time. So that is an unsecured note. Most notes are secured by the collateral, the assets with which the note is being used to purchase. So we'll look at somehow the ways that notes are secured. When we're talking about real property, in other words, real estate, a method of securing a lien or a security interest in real estate is a deed of trust in Texas. Texas is a deed of trust state. Other states may be what they call mortgage states. In a deed of trust state, you execute a three-party document, the deed of trust, which includes the lender, the borrower, and the trustee. The trustee is named, and the trustee's role is really that if there is a foreclosure with regard to the note, then the trustee's responsibility is to make sure that everything is done properly. Within a deed of trust, if the lender chooses to foreclose on the property, they must give adequate notice to the borrower. They must post notice at the courthouse, and then at certain time, there will be a sheriff's sale, which will take place on the courthouse steps. And essentially, what this is it's the sale of the property, and the borrower is, or the lender is usually the one who buys the property. So then, therefore, they can take title of that property, and then they can sell it to satisfy the loan. The warranty deed is the instrument that actually transfers the ownership or the title of the real property. What the warranty deed does is that the seller is guaranteeing that the title is free and clear of any encumbrances. Encumbrances could be a prior lien or deed of trust that has not been discharged. It can be a judgment against the property. It could be a tax lien or some other type of encumbrances that keep the seller from being able to give clear title. And so in the case of a warranty deed, the seller is guaranteeing that there is clear and free title and that they can transfer that to the buyer. The warranty deed and the deed of trust are both filed in the county courthouse with the county clerk's office in the county in which the property is located. Now, occasionally you run into a quitclaim deed. This is where the seller agrees to convey any interest in the property that they may have, but they're not guaranteeing that the property is free and clear of any encumbrances. Where quitclaim deeds are probably most often used is to clear up title for mineral interest which has been divided among many different heirs, for instance, and somebody may have, it may appear that they've got an interest, but they're not sure whether they do, and so they can use a quitclaim deed to transfer that interest without having any guarantee. The Uniform Commercial Code, we often refer to it as the UCC. These are the laws that govern tangible and intangible personal property. In other words, how to establish a security interest in personal property. Tangible personal property can be consumer goods, equipment, farm products. Intangible personal property is negotiable instruments, documents of title, accounts, or contract rights. One thing we need to point out here is that the difference in how a lien is established on a title vehicle, in other words, a automobile, a mobile home, or a trailer that may have that has a title. The way that title is, the way that is secure, the security interest is established through the titling process, and that the title is, if there is a lien holder on that loan, then the title will list that lien holder, and in fact, the owner of the vehicle will not even get a full title until that loan has been paid off or the title, that lien has been released. And so with title vehicles, the process of securing them is done through the titling process. Is the set of regulations under which we secure personal property. The parties within the UCC is the debtor or the bar, and the secured party or the lender. The secured party obtains a security interest or a lien in the collateral, and the security agreement creates this security interest. And now normally this is created by what we call a UCC-1, which is filed with the Secretary of State's office in Austin. Along with the UCC, you'll have a financing statement that shows the name and mailing address of the bar as secured party, and the description of the collateral that must be signed by both parties. The UCC is, as I say, it's filed at the Secretary of State's office in Austin. While a deed of trust has no ending date to it with regard to real estate, a UCC does have a termination date. And so as of a certain date, that UCC will no longer be in force. The reason that we see the filing of the UCC documents in the Secretary of State's office in Austin, which is considered to be central filing, what that allows is that a lender can search their database and determine whether there's a particular piece of personal property has been pledged as security for another loan. Since personal property can be moved around, it is important that the lender always go back and look at and see whether the property that the bar is putting up as collateral can be used as, in other words, where there's a first lien, in other words, the first encumbrance on that property, it may have been used as a security for another loan. And so that's one of the reasons that we have central filing. Now, some of the other instruments that relate to credit, and one of those is we don't see very often anymore, is the abstract, but the abstract is a compilation of all the deeds, mortgages, foreclosures, other pertinent facts that affect title to land. In other words, everything that's been filed in the courthouse with regard to a piece of land would go into an abstract. In the past, whenever you sold a piece of land, you would take the abstract to a title company. That title company would go back and bring it up to date, where all of the any filings from the last time it was brought up to date would be added to that abstract, and then an attorney would look at that and give it a title opinion. So in other words, there may be some aspects of that that needed to be corrected, some releases that may need to be obtained, so there would be a title opinion. Abstracts are no longer really used anymore because of the cost that was associated with bringing them up to date and to get the attorney's opinion. And so we go on to title insurance. And what a title insurance, the abstract company or title company will look at the documents with regard to a piece of land. They will determine whether or not there's any issues that need to be corrected. If not, once those need to be corrected, once they're done, then they will issue a title insurance policy, which guarantees the title. And this is a method that is much more efficient and less expensive than doing the abstract and title opinion. Some things that we need to define: a lien is a claim or encumbrance on property. It's established through either a deed of trust on real property or a UCC filing on personal property. And foreclosure is a process under which the lender exercises their right to take possession of property and to take and sell that property to offset the outstanding loan balance. Again, the foreclosure process is different from personal property versus real property. Bankruptcy is a process where a borrower who finds themselves in a situation where their liabilities exceed their assets, they can seek relief from that debt. Most common type of bankruptcy is a Chapter 7 bankruptcy, which provides for liquidation of all the assets. And then once those assets are liquidated, then those funds are used to pay against those debts. Within a Chapter 7 bankruptcy, secured creditors are those that have collateral and security interest in those assets. When those assets are sold, then they can take first claim on those. In other words, they have the ability to repossess those assets and then sell those to discharge that debt. The biggest problem with any bankruptcy is what we call unsecured creditors. In other words, those who do not have collateral or security interest in any of the assets. One thing about a bankruptcy, and particularly a Chapter 7 bankruptcy, is that there's certain assets that are protected. You can protect a person's what they call the tools of the trade. So there's a certain amount of the value of tools of trade that can be set aside, that cannot be sold, so that that individual can have the ability to continue to make a living. And of course, any debts within that bankruptcy that are being taken, that are not in default, for instance, a mortgage loan or a house loan or a car loan, they would not be part of that bankruptcy. A Chapter 12 bankruptcy is really a Chapter 11, and we'll talk about that in a minute. A Chapter 11 and Chapter 12 are reorganization situations. A Chapter 12 specifically relates to agricultural operations, while a Chapter 11 is other types of businesses. Now, the Chapter 11 allows debt adjustments. In other words, the business can go into a restructuring bankruptcy of Chapter 11, and what that does is it allows them to present a plan to the bankruptcy court. Once all of the creditors have agreed to that plan, then there may be some discharge or forgiveness of debt, and they're putting themselves into a position, hopefully, of being able to continue to stay in business and to pay off some portion of that debt in the future. In other words, it's just a reorganization of the business. A Chapter 13 is similar to a Chapter 11 in that to where you get to some discharge of debt in order to make it more possible for that individual to continue to service their debt, but it's more for a personal versus a business type of bankruptcy. Now, the Chapter 12, as was said, is specifically to agricultural operations. It was established back during the farm credit crisis of the 80s. It modifies a normal Chapter 11 bankruptcy in that there's what we could call a cram down rule. In other words, under a Chapter 11 bankruptcy, the plan of reorganization has to be approved by the creditors. In other words, the creditors have to agree that they're willing to accept the plan before the court will approve it. In a Chapter 11, or excuse me, a Chapter 12, the bankruptcy judge can force the creditors to accept the plan. So there doesn't have to be an agreement on the part of the creditors for the plan. And so this is one of the main differences between a subchapter 11 and a subchapter 12 bankruptcy. What subchapter 12 does, it gives farmers considerable power to demand concessions from their lenders. What oftentimes is that there would be, for instance, on a land note, there would be an appraisal done of that property, and the value or the amount of the loan may be brought back down to what the value of the property is. So we were looking at situations back in the 80s where the value of the collateral had gone down, and the borrower was not able to make the payments. Under subchapter 12, there could be a readjustment of the amount of that loan back to the value of the assets.